So we have some amazing news. The Bianchi, Maryland assault weapon ban case is now going back to the Supreme Court for review. This now sets the stage for a critical Supreme Court decision on rifle bans that will impact a ton of states, including California, New York, Illinois, and all those states that have put in place rifle bans. So let's talk about what is happening now in this case. But real quick, before we jump in this video, I want to ask you guys for a huge favor. I was looking at some of my analytics and about 60% of all my viewers are actually not subscribed to the channel. So if you watch these videos, if you enjoy this channel, please consider subscribing to the channel. That really does help. And it would be really cool to also reach 700,000 subscribers. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, I have some huge news for all of you guys, and it involves rifle bans and the Supreme Court. Second Amendment Foundation and FBC have now filed a writ of cert before judgment to the United States Supreme Court in the Maryland assault weapon ban case, which we've talked about, which is Bianchi v. Frosch. This now sets the stage for a critical Supreme Court review of a state rifle ban that can now have broad-reaching implications on all states, including states like mine, which is California, with their rifle ban. And this all comes on the heels of the Fourth Circuit en banc panel recently playing a ton of games and taking the Bianchi case out of the hands of the lower court after the case sat for over 13 months. SAF has decided to not wait for the Fourth Circuit en banc panel to sit on the case for another year, hear the case, and then sit on it and rule. Instead, they are using a mechanism known as a writ of cert before judgment to take this case back to the Supreme Court and get it back in the hands of the United Supreme Court immediately for them to strike down these rifle bans. Now, for some quick background on this case and why this rifle case is so significant, not just for Maryland, but all other states that have rifle bans, and to also just completely prevent any future rifle ban from ever happening. This ban was challenged in a Maryland district court, and in the complaint, the plaintiffs essentially had to concede that their Second Amendment claims were foreclosed at that time and at that district court level based on the prior Fourth Circuit decision on this issue. And that is because a case called Kolbe. A prior case called Kolbe challenged Maryland's assault weapon ban, and in the Kolbe case, the district court upheld the Maryland ban using intermediate scrutiny. And on review, a divided panel in the Fourth Circuit, in the Court of Appeals, they concluded that these rifles are protected by the Second Amendment and that the ban substantially burdens the right of self-defense within the home. So this is a prior case, Kolbe, that was ruled in the lower court, then made it to a three-judge panel in the Fourth Circuit. The three-judge panel in the Fourth Circuit sided with the 2A, struck down this law. But then, ultimately, what ended up happening is the Fourth Circuit en banc panel took a rehearing in that Kolbe case. And on review, the en banc panel in the Fourth Circuit upheld the Maryland state ban, finding that these rifles are outside the protection of the Second Amendment because they claimed they are useful in military service. And since they are useful in military service, they said that there could be restrictions placed on the possession of those items. So that is the Kolbe case. Now, this case, Bianchi, again, when it was brought, had to concede that the Kolbe precedent was out there, that it was controlling, but they claimed that it was incorrect and should be reversed. Now, the district court that reviewed Bianchi originally ultimately dismissed the complaint for a failure to state a claim, again saying because of Kolbe, they could not bring this lawsuit. That dismissal was then appealed to the Fourth Circuit, and the Fourth Circuit once again upheld that dismissal, saying, yes, we have to dismiss this case because of Kolbe. But then this case went up to the United States Supreme Court in 2022, seeking review on this issue, again seeking review and reversal of rifle bans. And the Supreme Court ultimately ruled in a different case, a landmark case that we've talked about, and that is controlling on this issue, which is New York State Rifle and Pistol Association versus Bruen. And in that, they found, among many other things, that the correct way to review the Second Amendment and these types of cases and using the right type of analysis is not intermediate scrutiny, it's not tier-based scrutiny or strict scrutiny, it's not none of that. It is actually text as informed by relevant history and tradition. And so, since they set the analysis as text as informed by relevant history and tradition, the Kolbe precedent and all these other different types of analysis that other courts had used, like in the Fourth Circuit, were no longer valid. Now, after issuing that ruling, the Supreme Court issued a GVR in this Bianchi case. That means that the United States Supreme Court granted review in the case, vacated the judgment down below, and then remanded the case back down for reconsideration in light of what they just said in Bruen. So it went back into the hands of the Fourth Circuit. That reconsideration requires that the Fourth Circuit rehear this case using text as informed by relevant history and tradition. Now, this case was opened back up in the Fourth Circuit, and the court held oral arguments before a 3-judge panel, but that happened all the way back in December of 2022. The panel that heard arguments in this case were Judges Niemeyer, Thacker, and Richardson, which meant there was a pretty good 2-to-1 makeup in our favor in that court. But as I mentioned, this case then sat for 13 months after oral arguments, and we received 0 orders from that court. But then suddenly we received an order from the Fourth Circuit en banc panel, which is the court that sits above the 3-judge panel. And ultimately what the Fourth Circuit en banc panel ordered is that they are taking the case out of the hands of that 3-judge panel, and they're going to take control of the case. So after the case sat for 13 months, there was no decision, no order by the 3-judge panel. The case was then stripped from the 3-judge panel, and it was going before the Fourth Circuit en banc panel, likely because they knew a favorable decision was going to be issued in our favor, striking down the Maryland rifle ban in light of Bruen, and they wanted to prevent that from happening. It's also very likely that the en banc panel there, that the judges there were behind the 13-month delay, and they were just kind of waiting, controlling the case, and preventing anything positive from happening, and now they took control of the case once again. But now the awesome team over at SAF, a lot of them I've had the pleasure of working with when I was over at FBC, Adam Kraut, Bill Sack, Lauren Hill, and then the attorney of record that filed this lawsuit, Ray. I've got to work with all of them. It's been a pleasure to work with them, and them also in conjunction with FBC. They have now filed a writ of cert before judgment, which is awesome news. This is a completely different mechanism, and it's a little bit rare. We don't talk about it a lot, but we have talked about it on the channel. Specifically, we talked about it recently in the Gazzola case. This is essentially a way to bypass hearings and rulings in lower courts like the Fourth Circuit en banc panel and instead go directly to the Supreme Court for an actual ruling on the merits. Now, what is really intriguing about this case is the fact that the Bianchi case was already GVR'd by the United States Supreme Court after Bruen. Also, the fact that this case sat in the Fourth Circuit for 13 months after the GVR with no decision, and then the en banc panel in the Fourth Circuit decided to take the case and pretty much do a bunch of shenanigans, prevent anything positive from happening, also may intrigue the Supreme Court to finally step in on this issue. Also, the fact that there has been a ton of other just nonsense that's been happening in the lower courts, in the Ninth Circuit, the Seventh Circuit, and others, may finally get the Supreme Court to step in and stop all of this madness. Now, the question presented to the Supreme Court for review is very simple, and it's what you want to see. Whether the Constitution allows a government to prohibit law-abiding, responsible citizens from protecting themselves, their families, and their homes with semi-automatic rifles that are in common use for lawful purposes. So the court is simply being asked to finally address whether these rifle bans are in fact a violation of the Second Amendment. Now, in the outset of their brief in the cert petition, the plaintiffs here point out that simply there is a ton of defiance after Bruen, and multiple circuit courts have actually defied what the Supreme Court had said. They point out that the Ninth Circuit is bending a bunch of their rules to prevent the Duncan magazine ban case, the positive decision there. They're preventing the magazine ban from being struck down in light of Bruen. And now there's a stay in the Miller case, which deals with California's rifle ban. So they point to a lot of the things in the Ninth Circuit. They point out how the Seventh Circuit continues to use the incorrect type of analysis to uphold the Illinois PICA, the rifle ban that they have in place, and the magazine ban that they have in place. And now you even have the Fourth Circuit here in the Bianchi case outright and just out in the open, just defying Bruen to protect Maryland's rifle ban as well. In their petition, they state that nearly 16 years after Heller, the time is ripe for the court to establish what should have been clear the day that decision was released. Bans on firearms commonly possessed by law-abiding citizens are simply off the table. The application of that principle to this case is plain. Modern semi-automatic rifles, such as the AR-15, traditionally have been widely accepted as lawful possessions, and today are owned in the tens of millions by law-abiding Americans for self-defense and other lawful purposes. Such arms simply cannot be banned. While granting certiorari before judgment is not standard operating procedure, the situation facing the court is atypical. A fundamental right is at stake. The proper outcome is clear, and the behavior of the lower courts indicates that this court's intervention likely is necessary for that fundamental right to be vindicated. This court should grant review and hold that Maryland's semi-automatic rifle ban is unconstitutional. So this is really great news, and I appreciate the aggressive approach by SAF and FBC in this case, trying to get this back to the hands of the Supreme Court. So if anything else develops, if anything changes, I will let you guys know. Also, I want to push you guys to go donate to these amazing organizations, SAF and FBC, who are fighting this battle for us, who are trying to get this back in the hands of the Supreme Court and strike down these rifle bans. I will leave links down below to SAF and FBC where you can go join and donate to them. So again, thank you guys so much for all of your support. If you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.